Hey, everybody, welcome to today's episode of The Free Lawyer. I'm glad each of you are here. Before we get started, I wanted to thank you all for the support you give the podcast. It grows every day. And if any of you regularly listen and you like what you hear, I would greatly appreciate it if you could place a rating and review, because it helps the podcast to be seen by more people, more lawyers, and that's what my desire is. So for those of you who have left a rating, thank you. If you have not, I would really appreciate it if you do, and share with another lawyer who you think can benefit from this content. And today's a very, very special episode. Mediation, I've learned in 45 years of trying cases, is so important. And we're blessed to have with us really one of America's premier mediators. Jeff Kichaven is a business mediator based out in California, does an amazing job, has a national reputation, and helps so many others. Jeff, thank you so much for being here.
Gary, thank you. It's a great opportunity, and I appreciate the invitation.
Great. So, Jeff, I know you practiced law as a litigator for a period of time. Tell me about your journey and how you switched to being a mediator and why.
That's a great question about the history, Gary. Thank you for asking that. I practiced business litigation for the first 15 years of my practice, and I loved it in the first several years, and I didn't love it so much in the last few years. And then a number of serendipitous things happened. One is the firm where I was practicing hit on a huge contingent fee, and every partner in the firm got several years' income dropped in our laps all at once.
Wow.
And that creates, shall we say, a certain latitude of thinking that did not exist before. At the same time, in the mid-1990s, mediation was coming into its own as a thing you could actually do professionally, full-time, particularly if you were not a retired judge. At that time, before then, there was such a thing as the rent-a-judge. And in the mid-1990s, professional mediation came into its own. And it was just right for me. It was close enough to being a lawyer that I felt I wasn't just throwing away my education and training, but it was different enough that I felt I was really doing something else, something different, something new. And because of having received my share of the contingent fee, I was able to begin the practice in an orderly way. I had 3 young kids in school at the time, and because of the financial cushion, I never had that white knuckle feeling of,
Right.
oh my God, if I don't have so many billable hours today, I won't be able to pay the mortgage or the tuition. And I'm very grateful for that. And I've never looked back. Developed
Fantastic.
this, and I love it more every day.
Jeff, you said you enjoyed doing the trial work for a number of years, and the last several years, not as much. In the last several years, what changed and why did you not like it as much?
My family was growing, Gary, and I wanted to spend more time with my 3 young kids, my family. And there was also an increasing sense of the razor's edge between perfection and catastrophe in doing litigation work, in that there's a specific person or team out there, opposing counsel, whose job it is to make you look bad and to defeat you. And it's their job to seize on every misstep, every mistake, every slip up. And so if you're not spot on with everything, you know that somebody's going to jump on it. And being on that razor's edge, as I call it, between perfection and catastrophe was, it was not a place I wanted to be anymore.
Yeah, I became a member of the bar in 1978, Jeff, and I've practiced litigation my whole career. And I've seen major changes in what it's like to be a litigator. You know, back in the day, I worked for the premier defense lawyer in Maryland, and we had a series of cases against the premier plaintiff's attorney. We just seemed to draw each other back to back. and my partner and mentor and the plaintiff's lawyer were extremely courteous with each other. And if either one of them made a mistake, the other would excuse it and say, that's all right. They just want to try the case on the merits, on the facts that were really disputed. And they not only didn't jump on the other's mistake, they would cover for each other. They would help them out of a box if they made a mistake. And it was such a nice way to try cases because you didn't have to be on that razor's edge. And the rationale was it was sort of professional courtesy because you might make a mistake this case, I might make a mistake next case, and we don't need to have that stress. But it's really changed now, where it's almost like the other side tries to set us up for failure. And maybe that's what it should be because we have clients to represent, but it does create so much more stress for lawyers. And there are many decisions we make during trials of cases and many mistakes that are potential. And that's why mediation is so beneficial.
And there are times, Gary, when as mediator, I have to take steps to enforce civility among lawyers. Sometimes I get the same kind of briefs that judges get and hate getting, where there's reams of emails attached, people bickering with each other over discovery issues or other things. And sometimes at the beginning of a case like that, I'll call the lawyers aside and I'll say, my friends, I've read the briefs. I've seen what's gone on before between you. All I can say is that was then and this is now. And lawyer one, you cannot settle unless lawyer two, you also settle. And lawyer two, you cannot settle unless lawyer one, you also settle. So today we're here with the same goal in mind, to see if there's any reasonably possible way to settle this case. And here, no matter what has happened before, here today, we're brothers and sisters at the bar, we're ladies and gentlemen, and we're working together to serve your clients better. And sometimes I just have to enforce that.
So many of us are trial lawyers. We know what mediation is and how it works. But from your perspective, why is mediation such an important part of the process today? And how do you best serve the lawyers, their clients, and the court system?
So it's a great and broad question.
Yes, it is.
There's so many things that we do as mediators to help lawyers, clients, and the court system or the administration of justice. First of all, we get cases settled and we relieve the court system of the obligation to process and handle and try many of these cases. The court system has things, the public safety issues, criminal law. They have matters to decide regarding the welfare of children in delinquency and dependency court. There's a lot of priorities in the court system, problems they must address. And commercial cases, private disputes between businesses and individuals are important, to be sure, and yet they're not quite as important in the scheme of things as issues of public safety, the welfare of children, and others. So clearing up resources is important. What we do for lawyers and clients is there's so many things. One is we allow people to make better decisions about how to handle their disputes. I've often said that the true goal of mediation is to allow clients to make clear, strong decisions in a calm, informed environment. Clear, strong decisions in a calm, informed environment. And when we do that, Gary, settlements are the natural byproduct of the process. Generally speaking, we don't have to use force, we don't have to use bullying, we don't have to threaten people. We help them lay the options before them, like a beautiful Viennese table of desserts. And when they see these beautiful, delicious opportunities of settlement set before them, most people, most of the time, are going to pick one of them. Normal people with normal psychological profiles want to get disputes behind them if they can in a face-saving way. So what we try to do is figure out what's missing. why hasn't this case settled yet? And we try to provide that missing ingredient so that people can put things behind them in a face-saving, reasonable way, move on with their lives and careers.
That's so true, Jeff. And Jeff, what kind of disputes do you most frequently mediate?
I do a lot of intellectual property cases, Gary, patents, trademarks, copyrights, trade secrets. I do a lot of insurance coverage cases. I do a lot of professional liability cases, legal and accounting malpractice. And then one of the beauties of being a mediator is you get something different every day. So when those emails go flying around the law firms and the listservs, does anybody know a good mediator for this or that kind of dispute? If you've done a good job for somebody on one kind of case, chances are you'll be able to do a good job for one of their partners on a different kind of case. So product liability, trusts and estates, real estate, all kinds of things come in, and the application of mediation skill and some common sense to all these different kinds of cases, applying an understanding of the attorney-client relationship is critical in almost every case. We can help people make those clear, strong decisions in a calm, informed environment. And lo and behold, almost all the time, these cases settle.
You were a litigator for some years and you were in the trenches. How does your experience as a litigator representing a client in a contested case, how does that influence or affect what you do as a mediator and your role as a mediator? What lessons did you learn from that that you apply as a mediator?
So I must pay tribute to my late mentor, Marshall Grossman, whose memorial service I just attended last Sunday. He was a titan of the legal community, the Jewish community, civic community in Los Angeles, and sadly we lost him last fall. His memorial service was just the other day. And he was a rough, tough litigator. He asked no quarter and gave none. Aggressive litigation is what he was known for. And I found even more so earlier in my career as a mediator, that my past association with him, mentorship, relationship, served me very well as a mediator. Because people would say to me, Jeff, you're a nice guy. You're a mild-mannered guy. Can you come on strong enough when you need to? Can you break hard truths to people? Can you tell it straight? Can you use a little muscle when you need to? And I tell people, and I told people, I said, look, I practiced for 15 years with Marshall Grossman. Mediation with me is not a kumbaya experience. We get down to it. We deal with the realities. We deal with them straight. We deal with them responsibly. And that's how we get cases done.
You know, often I've done some family law mediation and participated in many, and I know many parties come to a mediation with poor communication, with maybe some anger, with maybe some hostility towards the other side. Well, not
Maybe.
always. Sometimes it's just an objective business dispute. And I did some insurance defense, a lot of that. And then really, at least on the side of the insurance company, there's not that emotion to it. It's a business decision. But in many, many cases, there is that hostility and sometimes even anger. How do you, as the mediator, when you have two parties who are so angry at the other, how do you overcome that obstacle and foster a sense of cooperative communication between the parties?
The question of cooperative communication is critical, and how to deal responsibly with people's emotions. The first thing to recognize, Gary, is that people cannot turn off their emotions. You can't turn off your amygdala. You can't turn off different parts of your brain. We generate emotions constantly. So early in my career, I would hear people say, oh, check your emotions at the door. And I thought to myself, good luck. It's like saying, check your brain, remove your brain from your skull. You can't do that. You have to deal with people's emotional states responsibly. Now, people come into mediation all the time desperate to argue. Why is that? Because the only way they've been dealing with the subject matter of the dispute for months or perhaps years is through argument. That's all they've been doing with this subject matter, is arguing about it, listening to and even encouraging their lawyers to argue about it. So one thing I must remember as a mediator is do not get baited into argument. No mediator has ever won an argument with anybody about anything in a mediation. I don't care if your mediator is Abraham Lincoln. Your mediator could be Elijah the prophet. It doesn't matter. The mediator is not going to win an argument with you because you've been living, whether you're a lawyer or a client, you've been living with this case, living with this situation for months or years. The lawyers have been the ones doing the research, interviewing the witnesses, taking the depositions, appearing before the judge. What does the mediator really know? The mediator has read the brief that was submitted maybe a week before. It's an incomplete picture at best. So anytime I feel like I'm starting to devolve into argument with somebody, I have to check myself. And by declining to engage in argument with people, by listening carefully, listening for what's not being said as much as what is being said, the people who want to argue eventually run out of gas when they realize that I'm not going to argue back with them. And when they realize that they're not going to engage me in argument, well, we have to do something else. And something else is usually conversation, much more productive than argument in a mediation.
I do not have your experience as a mediator, that extensive experience. I did function as a settlement officer for one of my local courts. I got a lot of personal injury cases, also got some real estate disputes. And in the real estate disputes between neighbors, often they were extremely hostile. And what I want to ask you about is the importance of listening as a mediator, because I found when I gave each party an opportunity to vent their hostility, their anger, and sort of actively listened to them and reframed what they said, whether we settled or not, these two parties who couldn't stand each other, they'd walk out and separately say to me, I appreciate you so much. And I learned that one of the important things I feel in mediation is for a mediator to really give the parties a chance to be heard. Juries don't give them a chance to be heard. Their lawyers sometimes haven't listened to them, but I feel like being heard is a very important part of the process. What are your thoughts on that, Jeff?
I agree with you, Gary. The role of the client needs to be explored, understood, and appreciated. And as mediator, I try to be on the lookout for clients who have extreme emotional reactions to the process. And it's important to note there are two kinds of extreme emotional reactions. One is the conflagration, right? The person who's screaming, can't sit still, is agitated. That's an extreme emotional reaction. There's another extreme emotional reaction too, which we have to be sensitive to this as well. And that's the person who emotionally withdraws. The client who sits there with their arms folded and won't make eye contact and looks away. It's very difficult to have a client with that kind of emotional response be satisfied with the process or with the result or even with the performance of their lawyer along the way. So it's important for mediators, number one, to know how to wait out, how to deal with the extremely agitated client, to help that person calm down by modeling calm and hoping that the mediator's own calmness becomes infectious within the room. And for the client who is emotionally withdrawn, to engage that client. And sometimes you can do it by asking the client, what do you think? Or do you have anything to add? That sort of thing. And sometimes you have to be, well, you have to call one on yourself. And you might have to say something like, Mr. or Miss Client, I'd love to hear more about what you have to say. I wish that you would have an active role in the process, helping to craft the choices and decisions that affect you. Is there something that I could be doing here to make you feel more comfortable or more involved? Something that I could do to make the mediation a better experience for you? And some clients appreciate that. Everybody's an individual, Gary, and you have to use all of your experience, all of your common sense, whatever wisdom you're able to bring to bear to help people get get involved. Because when they're more involved in the crafting and the creation of the choices, they tend to be more satisfied with them. I think it was on a fortune cookie that I once read, you don't have to work very hard to convince people of the wisdom of their own ideas.
That's so true. That's
And,
so true.
and to
Jeff,
the
what do you think are some of the most common misconceptions lawyers have about mediation as a process? And what do you do to help overcome or manage those misconceptions?
I think there's a misconception that a lot of lawyers have, Gary, that the mediator is going to do their work for them. And one of the key distinctions that I draw between good mediation and bad mediation is that in good mediation, the mediator helps the lawyer do the best job possible of representing the client. And in bad mediation, the mediator takes over the lawyer's role.
Explain the difference from those. I understand the words you're saying in theory, but explain in practicality what that looks like.
So here's the acid test moment. You get towards the end of the mediation, there's an impasse, and the mediator comes down the hall and says, Gary, let's say you're representing the plaintiff. Gary, you've been mediating on a scale of 1 to 100, and you've been locked in demanding 80, and the defendant has been locked in demanding, offering 60. Gary, my friend, 65 is the best we can do. Please take 65. It's a good deal. Cash the check, get out of Dodge, whatever. Take it from me. This is what you ought to do. Now, what you don't know has happened is maybe down at the other end of the hall with the defendant or insurance company or whoever it is, and this could work both ways, by the way, plaintiff and defendant, the mediator might have had a conversation with the defense like this. Defense may say, look, we're at 60, they're at 80. I know you're a split the baby kind of guy, Jeff. Why, you're probably going to tell me 70, and I could probably squeeze my guy up to 70. But, we do a lot of cases together. I'm a good repeat client. We like each other. Why get me out of here at 65? Make me look like a hero to my client. Don't make me push him all the way to 70. I know that I could probably get him there, but don't make me do it. Now, when the mediator comes down to you and gives the spiel about 65 being a good deal and you should just do it, well, when the mediator leaves the room and your client turns to you and says, Gary, is 65 really the best we can do here? I wanted 70. How do you know, Gary, that we could not do better than 65? How are you supposed to answer that question? You don't know. I mean, you just don't know.
Right.
That is the risk. And it could work, either way, plaintiff or defense. If the lawyers sit back and just passively take the mediator's word for things, it's not right. You're not discharging your fiduciary obligation to your client. You're relying essentially on hearsay. You're relying on what the mediator has told you the other side would do. We all know from our evidence classes in law school, we went to law school around the same time, Gary. I graduated 1980. But we all remember this: hearsay is inherently unreliable. And in situations where you simply allow the mediator to do all your bargaining for you, I think it's a misconception that you're properly discharging your fiduciary obligation to your client. You got to eyeball the other side. Now, if the other side is a better negotiator than you and bluffs better than you, well, so be it. But at least you've given it your best shot as a lawyer to fulfill your fiduciary obligations to your client.
That makes a lot of sense. That makes a lot of sense. And I've learned that it's often you don't know what to trust about what the mediator says or doesn't say, or what he's saying in the other room. So I think it's always very important that I maintain my own independent thoughts about the case and communicate them directly to the mediator.
Mediators have biases. How do we know that? How do we know it for certainty? Because mediators have human brains rattling around in their skulls, and the human brain has biases. In California, we have to take mandatory continuing legal education on unconscious bias and subconscious bias. And yet somehow lawyers think that mediators are immune from these functionings of the human brain. And lawyers need to clear up that misconception and reestablish the proper division of responsibilities. It's the lawyer's job to negotiate on behalf of their client. It's the client's job to decide whether or not to take the best available deal. And it's the mediator's job to create the environment in which both lawyers and clients can do their jobs.
Very good. Jeff, for lawyers who aren't that familiar with mediation or have done it, but there aren't a lot of courses in mediation. We know how to try cases, but sometimes we don't know the best approach to mediation. What do you think are some important guidelines for a lawyer who's preparing for a mediation and then presenting his side to you as the mediator?
Gary, let me give a plug for the series of webinars that I do every week along with Jean Lawler and Natalie Armstrong-Motan. It's called the New Possibilities Hour. It's part of the Will Work for Food project. We don't charge for these webinars. We ask people to contribute to a food bank if they like what they see. Since we started the series in 2020 during the pandemic and lockdown, our generous audiences have contributed close to $550,000 to fight food insecurity worldwide. And if you look at the recordings of many of these webinars, we've had many of the country's leading litigators. We've had many of the country's leading law professors. We've had many leading in-house lawyers. We've had Jim Brosnahan from Morrison and Forster, a legend in California and nationwide, one of the leading lawyers. Ken Roberts from Chicago, one of the most sophisticated mediation advocates in the country. We've had the general counsel of Microsoft. We've had the general counsel of John Palmer from Microsoft.
So that's a great source for lawyers.
It's a great source. If you want to learn, if you spend 10 hours with our videos, you'll get a great education in how to be an advocate in mediation.
And at least for today, what do you think are the most important reminders to lawyers as to how to best prepare for and conduct a mediation?
The most important thing is to prepare. It's amazing how many people come in and they're sort of winging it, well, let's see what they'll offer, let's see what they'll take, without having devised a strategy. So how do you prepare properly? First of all, send the mediator a brief. Generally best to share the brief. If you share the brief and you still want to give the mediator something confidential, give the mediator a side letter. In the mediation brief, lay out, what is this case about? What's happened in this case? Share it with the other side so that the other side knows the state of the art of your thinking, because lawsuits are works in progress and good lawyers have new ideas all the time. After you share the briefs, have a phone conversation or a Zoom call with the mediator before the mediation. Why? Because some of the most important information for the mediator is stuff you will never put in writing. Stuff about the personalities of the parties and stuff about your relationship with your own client. Does your client have unrealistic expectations? Is your client blinded by rage and fury and jealousy and other emotions that are out of control? What lawyer is ever going to put that in writing? Nobody. And yet, as we were discussing earlier, it's some of the most important stuff for a mediator to know.
Really is.
Work with the mediator to fashion, is there something we can discuss productively in a joint session? something that, not a plenary session, not just tell me about your case, because that leads to conflagrations and, like thermonuclear mediation and throws things back. The remedy to that is not to avoid joint sessions altogether. The remedy is to fashion a joint session. What can we discuss productively? You look for something kind of antiseptic, shall we say. One good issue is, what is the right measure of damages? You say benefit of the bargain, I say out of pocket. Well, that doesn't really implicate the client's conduct. Clients can usually listen to that. It's not like asking somebody saying the proper subject for discussion is scienter. Did you intend to deceive? You don't want that sort of thing. But let's say you can fashion a joint session on an issue that's critical to the resolution of the case, an issue that's really keeping people apart, that's kind of antiseptic. You have that joint session. Then you can take it into a caucus, Gary, and that's where the magic happens. Because then I can say, Gary, you're advocating for the benefit of the bargain measure of damages. You know that it's a very important issue in the case. Other side says out of pocket, and they cite Hadley versus Baxendale. They think that's the controlling authority. What do you think about that? What did you think about Mr. and Miss X's points made in the joint session? And this is a lifeline to you, because you and I can have a conversation about what Mr. or Miss X had to say about your arguments. And you can acknowledge, well, maybe it's not a lead pipe cinch after all. Maybe it is more of a horse race. Maybe there really are two sides to the story. Maybe we have to take them seriously. And when you and I can have that kind of conversation in the presence of your client, we accomplish what we're really there to do, which is to open your client's thinking to some new possibilities, or some possibilities they had not considered before. Again, it gets back to avoiding argument. If I just go into a caucus with you and I've got the other side's brief, and I say, now, my friend Gary, you're arguing for the benefit of the bargain measure of damages, and I'm holding the brief, you understand the other side has three arguments against you. One, they cite Hadley versus Baxendale. What say you? Well, then I look like I am the sponsor of the argument.
Right.
I'm not just a commentator upon it.
Right.
And when I am the sponsor of the argument, then it's an argument, and it's much less likely to have a persuasive impact on your client, which is what we're really there to accomplish. So that's why I am a great advocate of joint sessions. Not always. Sometimes the situation is just too inflammatory. You can't put people together. Every case is different. I acknowledge that. But much more often than people believe nowadays, joint sessions, direct communication can be critical to setting the stage for progress so that clients can make those clear, strong decisions in the calm, informed environment we are working so hard to generate for them.
That's fantastic. Some great tips and great pointers, Jeff. Jeff, I call this podcast The Free Lawyer, as you know, and the reason I do is because it's my passion to help lawyers find personal freedom in their life, where they're not so stressed and overwhelmed. And I know you chose mediation because you find it fulfilling, and also you have more control over your calendar than you might have if you were still doing full duty litigation. What does personal freedom mean to you, Jeff, and how do you try to achieve that in your life?
Personal freedom is so important, Gary, and I feel I'm 67 years old, and I feel like I'm just starting to figure out what that's all about. Being a mediator gives me much more freedom, my sense of living, than being a litigator, because basically my nights and weekends are much more my own. Today's case was today, tomorrow's case is tomorrow. I don't worry that there's some associate staying up late in a high-rise building or their spare bedroom working hard to make me look bad. I don't always think, oh my gosh, maybe I should be working too. I just got married a year ago. My wife, Liz Ryan, is fantastic, and being in a wonderful, happy marriage, a great relationship, is a great incentive to work harder on a work-life balance, shall we say, spending
Yes.
time with her. I have 3 grandchildren. They all live in Los Angeles and want to spend time with them. And, their parents usually come along, and that's okay. That's okay. I love my children too. So that's one sense in which being a mediator helps to create a sense of freedom. And there's also a sense you get to a certain point in life and you develop a sense of security, or at least I find I develop a sense of security in myself, having more courage to say the things that need to be said, and developing the wisdom to know how to say those things and when to say those things, when not to say those things, how not to say those things. So the combination of courage and wisdom allows me to speak my mind and speak more freely, more constructively, and more productively than perhaps I could have done at earlier times in my life. Those are some of the things that constitute personal freedom to me.
Well, and I tell you, grandchildren are the most wonderful creatures in the world, aren't they? They just love their grandparents. We have 6, and it's fantastic.
And
Jeff.
staying in good health also creates personal freedom. I know there was a question on your list. One way in which Liz has been a tremendous influence on me is being in better health, and getting enough sleep, proper hydration, proper nutrition. These things are critical, and I'd be remiss in ending this free lawyer podcast without speaking on that subject for at least a minute or two, and saying that I get more sleep now, more hydration, more exercise, and it has redounded to my benefit in all dimensions of my life. And being free of, thank God I'm free of illness and hope to be for a long time. Just loving life.
Fantastic. Jeff, you're 67 and I'm 69, and I have a powerful focus on nutrition and wellness as well. And it's one of the things I talk about in many of my podcasts, because so many lawyers work so hard and under so much pressure that taking care of themselves mentally and physically is something they feel they don't have time for. And that can lead to some physically unhealthy conditions, mentally unhealthy conditions. And you and I are at a stage of our life where health is really really important to us. It's a primary focus, but I think it should be a focus for all of us, regardless of our age, because the healthy patterns, if they begin at 35, when we're under such pressure, can really build a good foundation for a long and healthy and prosperous life.
Gary, it's at every stage. When I look back at earlier stages of my life and think about less happy phases of my life, I think to myself, gee whiz, if I had gotten more sleep, if I had gotten more exercise, if I had had better nutrition, how much more effective would I have been in lengthy stretches of my life where I felt I was not as effective as I wanted to be and not as happy as I thought I deserved to be. So yes, and we go to Liz has introduced me to her nutritionists, to wonderful doctors and integrative and functional medicine, and acupuncture is only the beginning of the things that we do.
That's fantastic. That's fantastic. Jeff, for those who are listening who would like to perhaps get in touch with you for a mediation or some other purpose, how can they best find you?
Well, thank you for asking that, Gary. First of all, if people want to register for the Will Work for Food webinars, we do them every Thursday morning. The website for that is willworkforfood.news. That's willworkforfood.news. My email, I welcome emails. It's my initials, JK, at my name, jeffkichaven.com. My cell phone is area code 310-721-5785. That's 310-721-5785. I'm in the Pacific time zone. I welcome calls, but please be a little solicitous if you're not in the Pacific time zone of when I might be awake and when I might be asleep. I welcome LinkedIn inquiries and invitations. Anybody who's listening to this who would like to connect on LinkedIn, I'm very active on that platform. I welcome that. I treasure the opportunity, Gary, to establish relationships and support the lawyers and their clients whom I serve in my mediation practice. Somebody smarter than I am once said that the quality of our interpersonal relationships is the quality of life. And I want to thank you for inviting me onto this podcast, because I feel that you and I now have struck up a bit of a friendship. And
Yes, we have.
and I thank you for that. And the quality of my life is enriched by this experience, and I hope it is for you as well. I thank you very much.
It is absolutely. And I think what you just said is very important. Life isn't about getting stuff. It's really about the depth and quality of our connections with other people. And that's really what we should think about as we're on this journey, professional journey in our careers, is building those kind of connections and relationships that nurture us. Jeff, thank you so much for your amazing insights today. You're one of the premier mediators in the country, and I appreciate everything you shared. And for those of you who joined us today, thank you so much for being here. We both appreciate you. Have a great day, and please be well, be safe, and be free.